Good afternoon, guys. My name is Alina Shaltsova. I'm an immigration attorney from New York. In today's live YouTube presentation, I'm going to discuss with you the most recent immigration news. We're going to talk about new proposed public charge, adjustment of status. We're going to talk about how you can switch from one basis when you're filing for adjustment of status to another. And of course, I'm going to address a little bit the situation when and how a person may qualify for something called humanitarian parole in the United States. Why? Just, of course, it's relevant to the most recent events that we're all witnessing concerning Russia and Ukraine, and perhaps some of you will find this information helpful for their friends, family members, just give you some ideas as to what may be done for now while the United States considering their next moves. So thank you very much for watching. Please let me know where you're watching from. Say hello. Don't forget your questions for me. So in the end of the presentation, I'll be happy to answer them. And we're going to start. Well, first of all, I wanted to mention a little bit about the public charge. Public charge is the rule that may prevent some people from becoming a permanent residents in the United States or qualifying for the immigrant visa they're filing for, or in general when they're seeking admission into the United States. Public charge has been around from a very, very long time in the United States immigration law. Actually started all a long time ago when they first started molding immigration laws in the United States, when they realized that the United States is a nation of immigrants and they were trying to somehow address the issue of whether the person who comes to the United States will be able to sustain themselves in the United States. So it's been around for a long time, but of course it drew a lot of attention during the Trump administration. When Trump administration decided to change the standards for the public charge, because what was considered to be a public charge grant of admissibility was kind of subject to interpretation. So Trump administration decided to impose very strict rules under which a person who would seek admission into the United States would have to disclose their full financial history and history of their current liabilities and assets and history of the liability and assets of their family members. It was extremely difficult to pass this test. It was unfair and discriminatory, and there was a lawsuit that was aiming to resolve the situation. As you are aware, if you're watching this videos, immigration videos, the courts basically stopped the Trump version public charge rule from happening. However, that was not the end. When Biden administration took over, they stated that they're not even going to defend the Trump administration's public charge rule, and they got sued for that. Attorney generals of states like Texas, for example, filed a lawsuit challenging this current administration's decision not to pursue public charge rule that was formed under the Trump administration. And currently, this issue is going to be decided by the United States Supreme Court. It's important for the immigrants, just because if you recall, the Trump's administration's public charge rule would prevent many people from qualifying for immigration benefits. And if the United States Supreme Court decides that Biden administration should not have abandoned it, we may find ourselves in a peculiar situation where people who are filing for adjustment of status would have to again comply with very burdensome demands if they would like to demonstrate that in addition to the affidavit of support, they also can be self-sufficient. And if you recall, this rule would even apply to children. It's insanity. Recently, the Biden administration voiced their version of the public charge rule, which is much more relaxed, of course, and basically says that a person may be considered to be subject to public charge and admissibility only if they would become subject to long-term government institutionalization, meaning that they would have to depend on the government for a long term. Emergency Medicaid, non-cash assistance like food stamps would not even be considered for the purposes of public charge inadmissibility. Often I receive questions, what about unemployment? Guys, unemployment benefits, stimulus benefits that we were receiving during the pandemic are never counted towards public charge, and you don't need to worry about them. So this is an important update just because if you are planning on going through the process of adjustment of status, for example, you need to know about this. You need to be ready for this, and you need to keep your eye on the recent developments with regard to the public charge. I hope, of course, that Trump's administration version of the rule will not come back, because it would mean that a lot of people would simply not be able to pass this test. And Biden administration new version of the rule will become in effect. And of course, we're going to see what the Supreme Court is going to say. Now, wanted to also give you a short update about switching from one basis for Form I-45 to another. Maybe, for example, you filed your I-130 with a spouse, and then you decided, and you filed I-45 as well. And then you decided that, or maybe circumstances are such that you have to switch the basis. You have to switch, for example, under I-360 VAWA petition rather than I-130 petition. So in theory, it should be possible for you to request that USCIS does not charge you extra fees for the new I-45, but rather uses the fees and the forms that you submitted previously with regard to this new basis of the green card for the green card that you're going to be using. That's how it should work in theory. In practice, I usually advise clients, if they can afford financially, to just refile I-45, because it's been very difficult to do that. Recently, USCIS published guidelines as to how to request this switch, but with regard to employment-based categories only. They stated that they will allow to switch from one EB category to another, if, of course, both categories are current and if the category that the person would like to switch is current, and the person can show that they continuously maintained their legal status and their legal eligibility for adjustment of status. Now, it's a very good idea, but when you look into it deeper, you will see that people who will be able to benefit from it are most likely people who are in the backlog for EB visas, would be people from India and China specifically. And the difference between the currency of these two categories, EB2 and EB3 for them, would be maybe a year or two. I mean, it's a great beginning trying to use the visas that are available in the work sector right now. But of course, I feel that the government can do much more. And they can recapture, for example, visas that were lost previously and not used. In fact, they introduced the law, maybe some of you saw the law that they introduced a new short proposal to recapture visas for those who are in healthcare industry. Nurses and physicians would be able to, if the law passes, they will have more visas available to them. They would not be subject to countries' visa limitations, and it will be easier basically for nurses and physicians to receive green cards in the United States. So they are trying to do certain small steps towards using the resources that the government already has to resolve the backlog that we have in USCIS. But I'm going to tell you, of course, it's difficult. Now, the last point I wanted to talk about today, before I'm going to start answering your questions, so please, this is the opportunity to ask a question for free if you wish. I'm going to talk a little bit about the situation, Ukraine and Russia situation. I started receiving a lot of phone calls where people are asking me if people from Ukraine would qualify for any benefits currently in the United States. I think it's important to mention it here. Well, currently, the United States did not announce any specific measures that would help Ukrainian nationals to find shelter or asylum or any kind of status in the United States. The only thing that was announced recently was that people from Ukraine will have easier time coming to the United States, and they will not have to show that they complied with COVID restrictions protocols. However, currently, as of today, United States did not announce any specific parole, for example, program like it was announced for people from Afghanistan that would allow people from Ukraine to come to the United States. Now, you need to know that regardless of any special announcement, the United States immigration laws always allowed for something called humanitarian parole. It's true not only for Ukraine or Afghanistan, it's true for any national that if a person cannot receive a visa and cannot receive a green card, they may be able to receive what's called humanitarian parole. When somebody from the United States files for them for that humanitarian parole, it takes in practice about 90 to 120 days to receive authorization for it. But if granted, a person will be able to come to the United States and be safe here. In the past, I tried to file for such a parole for people from Ukraine in 2014, and the government rejected our applications. I hope that today, with regard to the situations that we're observing now, the government is going to change their position. Because before they would tell us that the people would have to find refuge with the United Nations High Commissioner on Refugees. Now, perhaps the situation is different. You need to know that if you have loved ones who could not receive visas, of course, because the consulates are not working anymore, you may try to file for them for that humanitarian parole. There is no not benefit. There is no drawback in filing for it. It's called humanitarian parole. And hopefully the United States will be able to perhaps help Ukrainian nationals in allowing temporary protected status or parole the way they authorized it for people from Afghanistan. This is unfortunately the only update and information I wanted to share, unfortunately, because I feel that we can do more and we should do more. And I know that AILO already is advocating for the US government to do more for people who are suffering from this conflict. And now, guys, if you have some questions, I'll be happy to answer them. Let me see. Thank you very much for joining. Hi, John. Hi, Nafisa. Hi, Ermal. Hi, Marie from Jacksonville, Florida. Yay. Hi, after game 24. Quick question. Didn't see a question. Please retype it. I see it. Hi, Massey. If intending immigrant lives in the United States with CO8 AD expired, would it be a problem to include the income to help sponsor to meet the poverty guidelines? Intending immigrant who is living with a work permit usually will not be able to become a joint sponsor. A joint sponsor can be only a person, or you mean that you or yourself are trying to be the person sponsored? Well, unless you can show that you already earned 40 quarters and will receive a total exemption from the affidavit of support, I would advise the petitioner to perhaps seek a joint sponsor rather than trying to use your income, just because usually an intended immigrant's income, it's very hard to qualify, but first of all for that, and second, you have to show that the income is earned legally, okay? But again, if you can produce statements from the Social Security Administration showing that you earned the necessary amount of quota towards your independence, financial independence, you may get an exemption, complete exemption. Hi, Manuel. My attorney filed I-1 36 months ago, and I'm yet to receive any receipt, but he said I should still wait. That's very unusual, I'll be honest. I had a delay once, a very long delay in receiving a receipt for the application, but it was I-360 application, and it was filed during the time when Vermont Service Center was moving. And that was the only time I had such a long delay in receiving a receipt. Never had such a long delay in receiving I-130 receipt. First of all, the question would be, do you have a tracking for the mail? Can you prove that the mail was in fact delivered? Do you know what happened to that mail? How do you know that USCIS did not reject it? So these are very important questions. You should discuss them with your attorney. Perhaps you need to file a duplicate filing just in case. Also, question, if you filed I-130, was the check cashed? If the check was cashed, on the back of that check, you will see the receipt number, okay? For that reason, I always advise to send a check rather than money order, because when the check is cashed, you will be able to see from your own bank records the receipt number for your application. And then, of course, it will be much easier to find the receipt later. Hi, Lisi, where to file for nurses to come to the United States? Well, nurses may qualify for special H1 visas, right? H visas. And you probably, an employer would handle such an application and petition. The Healthcare Workforce Resilience Act that I mentioned has not passed yet. When it passes, then it would allow nurses just to have more visas and qualify for the green cards in the United States easier. But if we talk about general immigration, I would suggest that you look into various employers who may sponsor nurses, hospitals usually. Hi, Lisi. Hi, Esha. How long does it take for I-601A waiver to be processed now? Excellent question. You don't want to know the answer. The processing times, I think, place the processing of I-601A waiver at 2 years, guys. It became ridiculous. Yes, very, very long time. That's where we stand right now with our 601As. Hopefully, the times will be shortened just because I feel that USCIS just started recovering from the pandemic. But of course, you always have to hope for the best, but prepare for the worst. Okay, so about 2 years. That's what the processing times are saying. Hi, Assad. Hi, Lena. Can you tell us which cases are on the interview process for affirmative asylum applicants in New York from Backlog? I mean, year 2016 or 15? I have to say that according to the reports from the New York Asylum Office, they are processing cases in 2016. They do not have cases from 2015 anymore. I believe they said that the oldest case they had, or Newark said that the oldest case they had was from November of 2015. So if you have a case in 2015 that you filed, it would mean that perhaps you moved and that caused the delay because cases from 2016 are being called. So are cases from early 2017. I know that because some of my cases that were filed in early 2017 are being called. This being said, you need to know that Asylum Office has a special order according to which they're calling cases. First priority goes to the cases that were rescheduled. Second priority still goes to the cases that were recently filed and are pending for 60 days or less. And third priority goes to all other cases, meaning cases that were filed a long time ago. And those cases are about 30% of the entire number of cases that are being interviewed. And of course, you also need to remember that USCIS still have to comply with COVID restrictions and they have diminished capacity in processing cases. That's why we have such huge delays. Hi, so Jano, my removal proceedings were terminated. Can I visit home with my advance parole? I once had a consultation with you months ago and you referred me a lawyer in Maryland. I think if we did have a consultation, you should follow my advice and advice of the attorney in Maryland. Because, of course, I cannot consult anyone publicly on a video. All I can tell you is this. And I can't even discuss particulars of your case. But let me tell you this in general. If you are able to receive advance parole, right? If you are able to receive advance parole, of course, you can use it for travel. Now, if, however, you always have to consult with an attorney before you do that, just because you may have a particular case where you're going to place yourself in a particular situation depending on what you filed for before. And as I said, because I cannot share any specific information regarding to specific case online, I would advise that you speak in private with an attorney before you would like to leave the country. Okay, if you receive advance parole, then generally you're authorized to travel. And of course, when somebody files for advance parole, they usually voice the reason as to why they would like to travel and when. So all this has to be discussed with a lawyer before leaving. Hi, Andy. I'm a U victim visa applicant, and I sent my bona fide determination work permit application 7 months ago. They said in the website 6 to 14 months. Do you think it will be more than 14 months for Vermont Center? Guys, I really will not be able to tell you. Unfortunately, there are huge delays in processing of the work permits, and I don't think there is any person who can actually answer this question with any certainty as to what's going to happen with USCIS. I feel that unless the government is going to hire a significant amount of officers, we will be stuck in this backlog because the backlog is growing and growing, right? Backlog of uh, work permits, backlog for adjustment of status cases, asylum cases. So all I can tell you that I would hope it's going to you if I would take average amount of time it takes to process work permits based on other categories, I would say that it should take you about 8 months. So if it's 7 months, 8 to 9 months to receive it. But I honestly would not be able to tell you more precisely. The good thing that if you do receive this work permit, it's going to be valid for 4 years. Hi, Maurice. I refile after a denial based on criminal record. My I-130 was approved. Have you seen any success in refiling? What are you refiling? Are you refiling I-45 application? Is that what's happening? Because I-130 usually has no connection with any criminal grounds of inadmissibility. So, of course, if you still qualify for adjustment of status and you were able to remove the ground of inadmissibility that used to be a problem, unless there is something else in your file, for example, misrepresentation of fraud or admission of committing a crime. Because remember, one may be found inadmissible not only because they're convicted of a crime, but also because they admitted to have committed the crime. It's very, very important. So refiling absolutely can work in certain cases, depending on your situation. Again, strongly recommend discussing it with a lawyer. So you'll be able to, lawyer will have to review your file and speak to you about your situation, see if potentially you may be charged with other grounds of admissibility. Because one and the same act may make you inadmissible on the different grounds. It's very important to know that. Hello, we filed February 2016, no interview yet. Yes, it's possible that people who filed in 2016 have not been called for the interview. As I mentioned, only 30% of old filings are being called for the interviews. So the line is moving, but very slowly. Hi, Fury Vlogs. Hello, I've been waiting for EAD card for 8 months now, and I got confirmation letter. Is this normal? I'm scared. What confirmation letter did you receive? Let me know. But answering your question in general, yes, unfortunately, it became a new normal that you're waiting for your work permit from 7 to 9 months. Very, very long time. If file I-601A in 2020, what waiver do I file for working out of status? Not sure. Depends on your situation. Why do you need a waiver for working out of status? If you have a US citizen spouse who was filing for you, unauthorized work is going to be automatically forgiven to you. Okay. Wouldn't be able to really answer without more information. Perhaps speak with your attorney, because if you see the thing, I-601A can be and should be filed only if you're inadmissible on one ground, unauthorized time or unlawful presence. If you think or somebody advised you that you potentially may be inadmissible on other grounds, I-601A is not the proper way, not the proper way to file. Hi, Maxime. My wife is a dependent in my asylum case. She might be eligible for EB1, 2, but we're so out of status. Do you think she might still have a chance in adjustment of status? Guys, to qualify for adjustment of status, traditionally, you have to demonstrate that you've been maintaining lawful non-immigrant status throughout your entire stay in the United States. Asylum pending is not lawful non-immigrant status. However, some people in certain very narrow situations were able to use matter of, I believe, LCOB to argue that they fell out of status through no fault of their own, but because USCIS took too long to consider their affirmative asylum application. So this is the case that you're trying to argue for with regard to your wife. You should discuss it with an attorney, depending on the jurisdiction, when asylum case was filed, how she entered the United States. You may want to try this route. However, remember, you will have to invest in it heavily, right? The employer will have to submit a petition, perhaps depending on the category you're filing, or if you're going through EB2 national interest waiver, then perhaps it will make sense for you to do that without the labor certification required. Hello, Gerium. What the process for getting legal status after 10-year rule, cancellation or removal? Excellent question. So 10-year rule, some people refer to it, cancellation or removal, can be filed for only if person is in immigration court proceedings. You cannot file for it unless you are in deportation, okay, or removal. To file for it, you'll have to demonstrate that you've been residing in the United States physically for at least 10 years, you did not commit certain crimes, your legal clock did not stop, you are a person of good moral character, that also you have a qualifying relative who is going to experience extreme hardship or rather exceptional and unusual hardship in case of your removal, and you are deserving cancellation of removal as a matter of discretion. Complex application can be filed only with a judge. You have to be very well prepared for it. There are cases where people ask the government to be placed in removal proceedings because they just want to try and apply. Another thing you need to know is that currently, if you win your application, you still have to wait for about 3 years before the government can issue to you your green card, because that's how badly it's backlogged. Okay, there are only, I believe, 4,000 visas based on cancellation of removal available, and there are many more people who are actually win their cases. So you will have to be prepared for a long way for that green card if you're filing for cancellation, but it can be a good option in certain situations. Hi, XYZ. Pending asylum applicant from September 2015 and waiting interview. Is there any hope for humanitarian asylum? It depends on the situation. Humanitarian asylum is given to those who cannot qualify for traditional asylum but can demonstrate that in the past they suffered serious harm due to protected ground, and if they're sent back now to their home country, they will suffer any harm. It doesn't have to be connected to the protected ground. So the relief is going to be dependent on your evidence, on how strong your case is, of course, but that's what humanitarian asylum is, okay? All right, you're welcome, Maxim. Maya Shukla, hey, how are you? How are you doing? Hi, Fury. Yes, I received a receipt notice that has receipt number. My case is for asylum. So is this a good thing that they will give me another work permit card? Because that will be the third card. Is there any chance? Just because you're receiving work permits, it's really not any indication for anything. Work permits, when you have asylum case pending, are automatic unless you do something to disqualify yourself from them. So it's not an indication that your case is going to be granted, just so you know. But of course, it helps to get a work permit. I mean, many people in the United States live for decades without one. And you should be considering yourself very lucky if you have it, because of course it makes your life much, much easier. Certain states would not give you driver's license if you don't have a work permit. New York now abandoned this practice, and anyone resident of New York State may receive driver's license, guys. You don't have to have now a legal status to be able to qualify for driver's license in New York. At least this is good news. Well, guys, thank you very much for watching. Thank you for joining. If you like this video, please like and share it. Subscribe to my channel. Don't forget, I'll be always happy to see you. I took a little bit of time off last week, but I'm back and we're going to have another live as soon as we have certain important updates. Or if not, we're going to meet again next week. Stay healthy, safe, and I hope to see you soon.